Hi guys, welcome back to my YouTube channel. Or maybe I should welcome myself back because I've been gone for a very long time. But I thought, you know what? It's the start of a new year and let me tick off some resolutions while I'm at it. One of the resolutions being that I need to be back on your YouTube screen giving the people what they want, which is legal education. By way of introduction, I am Tebelo Mutani. I am an attorney by profession and I am the founder of a platform called Sister in Law, which is a platform dedicated to empowering women and the community at large through legal education. First up for the year is, just an educational video on things to look out for on your employment contract. I know a lot of you started jobs at the beginning of this year. Some of you are going to start jobs in February. And even if you have already signed your employment contract, it's still important for you to, use this opportunity to gain clarity from your employer on certain things that you did not understand, or, just to refamiliarize yourself with the terms on your employment contract. The terms that I'm going to share are not, a closed list. There's obviously, a number of terms that you should look out for on your employment contract. But I'm just going to speak about a few of the ones which I think are important just to set the tone for your career. First thing that you should know about your employment contract is that the terms on your contract stipulated by your employer should not be less favorable than the terms that are stipulated or rather prescribed by the Basic Conditions of Employment Act. This, for example, means that if let's use maternity leave as an example. The Basic Conditions of Employment Act states that maternity leave should be for a minimum of 4 weeks. If your employer, a minimum of 6 weeks, 6 weeks. If your employer has then imposed terms that are less favorable than the terms that are enlisted on the Basic Conditions of Employment Act, then that is already unfair and already putting you on a back foot. So just be aware of that. And while I'm on the topic of maternity leave, one thing that I want to stress is that companies differ with their policies with regard to maternity leave. Some companies don't pay for maternity leave at all. And, that is, completely the discretion of your employer. Some companies do pay, but they give you a reduced salary. And then some companies give you your full salary during your maternity leave. So your maternity leave can range anything from the 6 weeks that are prescribed by the Basic Conditions of Employment Act to 4 months, which, a lot of people opt to take most of the time, which is completely okay with the employer, especially if they have opted not to pay you during your employment or rather during your maternity leave. If your company is not paying you, for your maternity leave, then you will be able to claim from UIF. That is a completely different procedure and it is not forming part of today's video. So just do your research before you take maternity leave on that issue. The next thing that I would like to point out for you to be aware of on your employment contract is obviously your salary. Know what your salary is and make sure that it's the terms that you had agreed upon before you signed your contract. Make sure that you understand issues of overtime. Make sure that you understand other disbursements that you can claim over and above your salary. So this would be overtime, petrol, car allowance, phone allowance, so forth. Just understand as well that not every single company can pay for overtime. And sometimes it is the nature of your job that you work slightly longer hours, So for example, I know if you're an attorney and you're serving your articles, you're not always going to work 9 to 5. You're also going to put in weekends. And those will be things that you can't, or rather expenses, time that you can't claim a salary for from your employer or to be paid overtime. But for example, if you're a candidate attorney, there are certain things you're allowed to claim from the company, being your travel allowance. Sometimes if you, used your car or used your money for, serving documents or whatever the case is, going to court, whatever the case is, you can claim for such disbursements. Once again, it's obviously something that you need to look at your employment contract for to be aware of. Another thing that you should be aware of on your employment contract is your duties. Now, like I said, sometimes the nature of the job itself will, will require you to do certain duties over and above the duties that were drawn out for you during your interview stages and during, your onboarding. So just make sure that at the bare minimum, you are meeting the job spec and you are meeting what your employer has recorded on your contract. But that doesn't mean that just because something is not recorded on your contract, you shouldn't do it. That would be very bad advice. The advice that I'm prescribing to you is that be aware of what your minimum expectations are from your employer, and obviously be aware of issues of, what is it called, when you review, do a career review 6 months down the line. And a good time obviously to review is also after your probation. So if you've been at a company for 3 or 6 months, go back to your employer and say, when I first got here, I didn't know how to put together an Excel spreadsheet. Now I know how to. I'd like to know how I can continue improving so that I can last beyond this probation period or beyond this year contract. While I'm on the topic of probation, familiarize yourself with how long your probation is. Some companies it's 3 months, some companies it's 6 months. The probation period allows your employer and yourself to sort of test the waters to see if you guys will be a good fit for each other. In as much as it is the employer, auditioning you during those 3 to 6 months, it is also up to you to audition the company, so that you can decide if you fit in with the environment, if you fit in with your colleagues, if you fit in with the culture. I don't like using that word because whatever, I think it's just a term that companies use to sort of lure you into coming to work for very toxic environments sometimes. But that's just my personal take. But yeah, do be aware of your probation periods as well. Probation in itself and the process that has to be followed, whether or not your employer is going to keep you or let you go after, is going to be in a different video. It's not for today's topic, but it is something that I want you to just be aware of when it comes to your employment contract. Another important thing for you to be aware of on your employment contract are your leave days. Understand when is your annual leave, how often can you take it. Understand where you fit in with family responsibility leave, your sick leave. Understand the, what is it called, turnover period. The word isn't coming, but basically just know that sometimes sick leave cannot be carried over after 3 years or something like that. Obviously I need to brush up on this, but it is something I want you to go and familiarize yourself with on your employment contract. One thing that I also want to state about leave is that you must ensure that the leave that you are granted is also in line with the Basic Conditions of Employment Act. The terms of your leave cannot be less favorable than those that are prescribed by the Basic Conditions of Employment Act. So that means that if the Act says the number of days is 20 paid annual leave days, your employer cannot impose 15 or 14 days, whatever the case is. So just make sure that your leave days and the type of leave that you can take is aligned with the Basic Conditions of Employment Act. I know that some companies give study leave, and that is purely at the discretion of the employer. And while we are discussing study leave, I want you to make yourself aware of any policies that may exist with the study leave policy of your employer, because some employers say we'll pay for you to do your honors or your masters, but that means that after your qualification you must serve us for a year or continue to be in our employment for a year. Obviously you will get paid for that year, but you're also using the year to pay back your employer for your studies. Some companies then say if you do leave before that year is over, then you have to pay back a certain percentage of your studies. So please do familiarize yourself with that. If it is not in your contract and you are planning on being in the company for a little while, go to HR, go to your employer to find out if you were to, if they were to fund your studies, what are their expectations in terms of how you can pay back. For me personally, I always say if something is not on your contract, there's nothing that precludes you from negotiating this term into your contract and then asking your employer for an updated version of your contract. Both of you sign on the new terms that you've agreed upon. And lastly, one of the things that, well, one of the last things that I want you to be aware of on your employment contract is the dispute resolution process. Understand the disciplinary hearing process. Understand what happens, if you have committed a certain offense. There are certain offenses with which warrant a written warning, and certain offenses warrant immediate suspension, whereas other offenses then warrant you being fired from your job. So understand, if I am suspended, is it because I had is it because you had 3 written warnings prior to the event of your suspension, or is it an offense that doesn't require you to have 3 written warnings before the suspension and that you'll just immediately be suspended? Understand what happens to, i.e., your salary, your work, your duties in that suspension. Do you still have to continue reporting to your employer on a daily basis? Are you going to work remotely, or do you hand in your laptops pending the investigation against you? Please, that's very important. And then also understand what procedures are followed in the event of your suspension. I know certain internal disciplinary hearing procedures state that you cannot have a legal representative during the proceedings, but just familiarize yourself with those internal procedures. I think it's very important, because sometimes you could be doing something blindly, not being aware of the fact that it is a offense that warrants a written warning. So please make sure that on your contract you understand the company's internal dispute resolution and disciplinary hearing procedures. If it isn't tabled in your contract, it is still a good thing to ask HR about, ask your employer about, and maybe around the office, depending on how big your office is, you might find that in the common seating area and the mutual area, i.e. the kitchen or the lounge, the beanbag area, or whatever chilling area you have in the company, there might be a big poster that highlights the disciplinary procedures that you can anticipate in the event of you having to undergo those hearings. I hope it doesn't happen, but just understand the process anyway. Thank you so much for tuning into the first video of the year. If you have any more questions pertaining to your employment contract, please do not hesitate to contact me. My email address is advice@sisterinlaw.co.za. That's ADVICE@sisterinlaw, one word, .co.za. Do follow me on my social media pages at Sister-in-Law on all platforms, or at Bells_Motshwane on all platforms. I hope to see you on the next video. Bye.